Hello, ladies and gentlemen. Daniel Forouzan here with the next episode of the Schmoozin with Forouzan podcast. Very excited. Brian Kabateck is on the podcast today. Brian, how are you, sir?
I'm outstanding. Thank you very much for having me. I'm looking forward to this.
I've known Brian for a lot of years. I've been following his career. For a guy like me to have a guy like Brian on, it's a big deal. I get to pick the brains of a guy who's effectively a legend in the industry, has been doing very large verdicts, very large settlements in various areas of the law, has a very large law firm. So, Brian, your time is appreciated. Not that I haven't already told everyone a little bit about you, but please just go ahead and tell us a little bit about yourself.
Well, I think that, most of the salient facts are probably similar to most people out there. I went through undergrad, I went to USC, and then I went to Loyola Law School for my law degree. I went in the evenings because I wanted to come out of law school being able to be debt-free. Now, when I graduated in 1989, that was possible. Law school was a lot less expensive 30-some years ago than it is today. And I worked during the day as a law clerk, and then at night went to law school. So I learned really good study habits and work habits as a result of that. Unlike a lot of people who get into their first job and they don't understand working 60, 70, 80 hours a week. I had already worked 80, 90 hours a week because I considered it like two jobs. So I went to a very large firm initially out of law school, Shepherd Mullen. And then after that, I went to a very tiny firm for a very short period of time, and then ended up at a relatively small firm where I eventually became partner and named partner, and then split off in 2002 and started my own firm downtown Los Angeles. So we're over 20 years now doing this. And my practice is, I try to tell people I'll do anything on a contingency, anything at all, from a business case to a personal injury case to insurance bad faith. I've done a lot of insurance bad faith cases over the years, to class action cases, to employment cases, to anything that can come in the door, fire cases. We've been doing a lot of those. So I've been very fortunate to have a very, very interesting, robust career.
I want to talk about what you just said, how I'll take anything, I'll take things on a contingency. That's the way you go about it. But just as a side note, I don't know if you remember this, you were actually at my Loyola Law School evening program orientation. And I still remember what you said. You said, hey, once I got out of law school and I started working full time, I had more free time. Hey, I can get a haircut now. This is excellent. Everyone in the room laughed.
True story. That's true. Yeah.
Yeah, everyone in the room laughed, myself included. I also did the evening program. I worked during the day. I went to law school at night. So I certainly know how that's like. But let's talk about this. This is an interesting thing that you said, Brian. In the world of attorneys who are all specializing, and there are attorneys out there who do things a little differently. I'd like to think I have a little bit more of a broad scope practice. I don't just do PI. I don't just do employment. I do abuse. It struck my ear when you said, I want to do it on contingency. And it sounds like you do a wide array of things on contingency. Tell me your thoughts on that.
Well, I think, first of all, it depends on, what your bench strength is like. And I've got, 3 great partners, and we've got about 10 more lawyers on top of that. And people have different expertise in different areas. And, also it can be fair, there are certain areas that I wouldn't do on my own. Let's underline the words my own on a contingency. For example, some kind of a potentially a trademark or antitrust or something like that. I probably would look for co-counsel or look to work with somebody who actually knows that area. But I think the truth is that after you've been practicing for a number of years, there's a lot of these areas of law that you can master. Now, I started out pretty early in my career doing insurance and understanding insurance policies, understanding how they work, understanding they operate. And I think there's a good lesson to be taken from that. I think the lesson is that many people get scared of something like insurance because they don't know it. Right? They go, oh my God, I can't understand a policy. I can't, it's so complicated. It's so confusing. It's a defined area of law, right? I mean, there are specific cases on it. People have written treatises on it. You can research in all 50 states how policies interpreted in one little clause. It's, the policies are standardized. So I see that a lot of times people kind of shy away from stuff because they go, oh, I don't know. I'm a great PI lawyer, but I can't understand opening up a policy, for example, which is an area that most PI lawyers don't completely understand. And I think the takeaway from that is, don't be afraid, but also don't be afraid to associate with somebody too, right? If you don't have 100% confidence in that particular area of the law, don't be afraid to associate with somebody. We do it all the time. So I think those are good takeaways from it. And I think it's important for people to understand that you're capable and competent and you can do it. I mean, I'm just fortunate to have a not, I guess by plaintiff standards, a moderately big firm, but not a big firm. But we will learn the area, we'll understand it, and I think there's a lot of lucrative areas out there in the plaintiff's practice on a contingency that people shy away from.
It's interesting to hear you say all that. I have worked at a previous firm, a personal injury firm, and I thought sometimes that cases would come in that were worth really taking a look at, but because the practice was somewhat standardized and almost cookie cutter, the powers to be at that firm, yeah, they didn't want to take a look at it, which I always thought was unfortunate. Now, thankfully, I have my own practice. I can make those decisions myself. Speaking about having one's own practice, or frankly, the practice of law, there's been a lot of stuff going on in regards to who can practice law, who can own law firms, whether or not the bar examination is a requisite to licensure in the state of California, and various other things. I know that you were kind enough to be on the West Side Bar Association's panel on that topic. I think it was in 2020. Things have changed a bit since then. So I thought maybe we would dive into it. I also always like to start talking about state bar issues with the following. I've been on the state bar phone calls. Brian, you may have been on them as well. Some lawyers call in and are outright rude, nasty, and hostile. And as the president of the WBA, I also hear chatter, and I hear lawyers saying some things that are maybe a little less than professional. I just want to start out by saying this conversation is held with nothing but utmost respect for the state bar. We appreciate that the state bar regulates our practice. We appreciate the state bar is doing what it perceives to be in its best interest, as well as the best interest of justice for the consumers of California. So nothing is said here with any intention of disrespect. Nothing is said here with any lack of appreciation for a job that probably goes underappreciated, frankly, at the state bar. That all being said, let's talk about this paraprofessional program. For those of you who don't know, the idea is, and I'm lumping things together, but generally the state bar was looking to make it such that non-lawyers can practice law and non-lawyers can own law firms. Brian, what say you?
Well, there's a lot to say about that. Let's first start with, I think, the easy part of this, which is there is a problem with underserved areas of law, not communities so much, but areas of law, because I do believe that all areas of all communities, racially diverse, sexually diverse, whatever it may be, are well served by the plaintiffs' bar. I mean, there is plenty of lawyers out there who are extremely competent, who take all types of cases. There are areas such as family law, child custody issues, domestic violence issues, which we know are underserved. We know that. And that's a problem, and we need to address that. But this seemed to me to be like a bull in a china shop. And it seemed to me that the concept here is we're going to let non-lawyers own law firms. We're going to let non-lawyers practice certain areas of the law or be involved, engaged in certain areas of the law, is so clearly, even though, and let's face it, the road to hell is paved with good intentions, is so clearly an initial intention is we got to help these underserved communities. But what is going to happen is very large moneyed interests are going to get into the personal injury area and potentially other areas of law practice. And it's going to be completely unregulated. It is going to be, it is just going to turn into, frankly, a shit show for people out there, for the people out there who are suddenly going to find themselves, being inundated with advertising for Walmart-like services for basically and fundamentally what we do. So there's got to be some solutions, right? I mean, there have to be some solutions, but right now, as we know, the legislature's put a pause on it. They said, you're not going to do that. They've told the bar, you need to focus on what your job is. And remember, and I think it's important that the listeners here understand something, which is until a few years ago, half a dozen years ago or so, the state bar was sort of a complete service to lawyers. They had sections, they had membership, they had, continuing education. You were a real property lawyer. You go and you become part of a real property section with all these lawyers throughout the state of California. That completely changed. Legislature changed that. They stripped that all away. Fundamentally now they have two functions. One, they license. Two, they discipline. And it's no longer run by lawyers. It's run by appointed people. It's a bureaucracy. It's kind of like the DMV. I mean, that's what it is. And what we now have is people in there which have said, hey, we want, to have something else to do. We want to look at something else. We want to look at this issue. So they're looking at that issue, and they're also looking at the bar exam and what they should do with respect to the bar exam. So in my humble opinion, they got way over their skis, and they started looking at something that they thought that they had a mandate, or they should have a mandate to do. And it's kind of, insane. I do believe that we need to figure out a way to help better serve those areas where average people don't have access to lawyers, don't have ready access to lawyers. Remember, 90% of the people in this country don't have ready access to lawyers. They can't pick up the phone and call somebody and say, I need a lawyer for this. I need a lawyer for that. So there is a problem out there, but it's not in the civil personal injury / contingency world. There's plenty of lawyers who are ready, willing, able, and very capable of handling their cases.
Yeah, I would have to echo your sentiment. It struck me as a broad brush approach, as you put it, bull in a china shop, whatever you want to say, sledgehammer instead of a scalpel. And look, every lawyer out there has had that phone call where someone says, hey, I spoke to this person. They didn't tell me they were really a lawyer. They said they were a law clerk, but they could help me with my case. And they made a claim with the insurance adjuster and blah, blah, blah. And now the case is a mess. And they come to my office, your office, or another competent plaintiff's firm, and it's our job to undo the mess that was made. So I always wonder, what exactly ultimately they're expecting. I can certainly appreciate the intention. I think we're both on that same page. No doubt there's a domestic violence survivor out there who is unaware of her rights, doesn't believe, well, it could be a he or she, I'm going to say a she for the sake of this conversation, but doesn't know her rights, doesn't have the finances for a retainer, doesn't even know that there's possible services out there that could help her without the retainer. Rather than, pouring resources directly into that, it seems like they've taken a wider scope. What is your take on how the legal community responded to the paraprofessional program?
I thought it was phenomenal. And what I thought was great about it was it wasn't just, my community, our community of plaintiff lawyers. It was the organized bar. It was the LA County bar. It was, white shoe, big firm lawyers. It was small firm lawyers. It was people across the board. And, it's true. There are some lawyers out there who thought this might be a good idea. But I thought the way that people coalesced around this issue was phenomenal, and they went after it. Now, there's criticism out there, and they say, oh, we're just protecting the profession. We just want the practice of law open to those people who have a bar card, who are subject to the state bar. And my answer to that is yes, that's right. That's what we're trying to do, is make sure that it is well regulated.
Yeah, I appreciate that. Also, there are plenty of organizations out there, Kabateck and various other ones that exist that have been clamoring for more resources, which, correct me if I'm wrong, they do a lot of the things that we're talking about in terms of increasing access to justice for maybe some of the more vulnerable people out there. I always got the feeling that going down the paraprofessional, going down that was a little bit of a slight to these types of legal aid organizations who have been around the whole time doing the good fight with minimal resources. What's your take on that?
Well, I think that those organizations do great work. I think they are underfunded and understaffed, and there certainly could be solutions to that. If the state of California decided that this was a problem and an issue that they wanted to fund, they could better fund organizations like that. They could come up with ways that lawyers supervise paraprofessionals, which already exists, but maybe in a more broad sense. I think that those are all very valid issues to look at, but at its core, people don't know how they're going to get to these lawyers. And I'm talking about like the good nonprofits like Kabatck, Neighborhood Legal Services, Legal Aid, etc. They don't know exactly how to get there. They don't know what their rights are. They don't know how exactly to do it. So there is a disconnect there. There's no question. There's a problem there. And I think those lawyers out there that say, oh, this is a good idea, I don't think they fully comprehend what would happen if these if for-profit corporate ownership of law firms started to occur.
Yeah, I think it's one thing to judge an idea based on its intentions. It's another thing to judge an idea based on its likely outcome. And those could be two very different things. As you said, the path to hell is, comes with good intentions sometimes. Let's talk about the non-exam pathway. Let's focus on that a little bit. What's your take on that?
Well, I have several things on takes on that. First of all, I look, nobody likes the bar exam, right? It was an unfun chapter in our lives, but it also gave some basic fundamental foundation to the practice of law. Now, in my opinion, I think we should have a bar exam. And then I think just like accountants have to put in so many hours before they become CPAs, we should have some kind of system where new lawyers, and I'll put that in quotes, new lawyers, because you've passed the bar now, you've now got to put in so many hours, 3,000 hours or something like that, under the tutelage of a mentor. We can define that. And you work under that person's license. And then he or she, at the end of the day, certifies that you've worked those hours, and then you're qualified to become a lawyer. And the reason I think that would be important, I know I'm getting a little far off the bar exam here, but our reason I think that's important is because we need some level of competency that goes beyond law school and a bar exam. Because it is true that particularly people that perhaps can't or don't want to get a job in a firm, the day they pass the bar and they get sworn in, they can hang out a shingle and they start representing the public. And in my opinion, very few people that day are qualified to represent clients because you don't know what you don't know, right? So let me go back now to your issue and let's talk about this bar exam issue, which is, it's now 2 days. I think that we have bent already to the notion that in some respects, the bar exam may be discriminatory. In some respects, it may be unfair. In some respects, it may be too hard. Yes, and so's life. Life is sometimes too hard. And if you can't pass a fundamental basic bar exam, then maybe this isn't the job for you. I mean, it's the same reason why we know this, because I'm involved in law school. I'm involved in the legal community. We know that getting a halfway decent score on an LSAT will indicate how well you'll do in law school and how well you'll do on the bar. It may not indicate if you're going to be a great lawyer or not, but it will indicate that. So let's also look at this, because Daniel, you went to Loyola, right? Okay, so Loyola has, consistently between 80 and 90% of its first time takers pass the bar. Yeah. And, that's true for most of the good, well-ranked schools in California. If you're having trouble passing the bar, there's a problem. Is it the law school? Is it you? Is it you don't have the aptitude? Did you have bad professors? There is a problem. So why do we want to take at least one indication of whether or not somebody is competent enough to be practicing law away from it?
Yeah, the bar is an interesting thing. A lot of what you said there caused me to think. One thing I'll say, and I'm going to explain myself so I don't sound arrogant, but let me not bury the lead. I never thought, I'm not some genius by any means, but I never thought the bar examination, it was, as you said, not a fun experience, but I never thought it was this hellacious, beastly exam. Sure, what you have to know is hellacious and beastly, but at the end of the day, as I understand it, it's graded on quite an aggressive curve, which means effectively you only need to show minimum competency. You don't need to show anything beyond that. So I always found the examination to be, yes, it's terrifying because you have to learn contracts, property, torts, con law, probate. You have to learn all these areas of law, which you're probably not even going to practice. And insofar as the understanding and acceptance of the material, it is an undertaking. But as far as the grading of the examination, as I understood, effectively getting like a 60% will get you in there. A 60% in college is a D. It's a D minus. So a D minus F plus will get your foot in the door. So look, maybe there's something that needs to be said in terms of approaching this differently. Maybe some type of mentorship, like you mentioned, is probably the way to go. But insofar as eliminating the examination as a whole, I would certainly agree with you. That seems a little bit much.
I mean, it seems to me contradictory. On the one hand, the bar says we're going to step up our role in disciplining lawyers, and on the other hand, they say, well, we're looking at getting rid of the bar exam.
Yeah.
I mean, explain that to me. That just doesn't seem to make any common sense at all. I mean, I think a lot of what the bar may be doing these days is throwing the stuff out there. They get a little committee together. There are certain law professors or law school deans who, are behind this issue, trying to advocate for this issue. I also recognize that in some minority communities, testing and their level of skill set is harming them. There is no question about that. The Black people are underrepresented as lawyers. There's no question about that. I mean, and that's true with a lot of communities. So, but this isn't the solution to that. One of the solutions to that is step up education, get lawyers like us into high schools and even into junior colleges to go talk to people and say, look, law is a great path. It's a great area that you can pursue. It's something you could do. But getting rid of the bar exam just doesn't seem to me to be the answer at all.
Yeah, it sounds like the common thread here is we agree with the intention, we have issue with the execution. And to be frank, everyone I speak to seems to be on that page. No one's saying, hey, we want less people who are victims of domestic violence to have access to justice. Of course not. No one's saying, hey, we want to uneven, lack of equality in terms of the representation, where you want the ideas, you want representation of California in the bar itself, and if that's not happening, then that needs to be addressed. But to then throw the baby out with the bathwater and get rid of the examination altogether, it just seems like there is some heavy-handed approaches. And I find it interesting that you're saying, they're throwing things out there, they're thinking about it. Every time they throw something out there, geez, it sure creates a brouhaha amongst the lawyers. But I get it. Let's talk about the field of consumer law as a whole. What I like about you, Brian, and what I like about your practice is, like I said, I've noticed you do different areas of law, big stuff. You do big stuff, but you do big stuff in various fields. And I think that's interesting. Let's talk about consumer law generally. I remember I was in law school, and Iskander, I think, came out around that time. Actually, I think someone who was clerking for you at that time, a classmate of mine, Drew Ferrandini, who unfortunately recently has passed away, I regret to say. But he actually brought it to my attention. He says, look, I'm working at Kabateck's firm in class action right now. We're seeing these class action waivers and this and that. And he was telling me about that. That was about 10 years ago, and here we are today. What is your take on the field of consumer law generally?
Well, I think consumer law, and probably everyone that's listening to this would agree, consumer law has an important place in our society in America and in the general safety. And, without sounding too much like I'm on a soapbox here, cars are safer. Sometimes drugs are safer. That's a debatable issue, but products are safer. And the reason they're safer isn't because, a car manufacturer wakes up in the morning like they've been visited by the ghost of Jacob Marley the night before and have an epiphany that they want to make their products safer. They make their products safer because they don't want to get sued. And that's one of the reasons why, people in their ordinary daily lives act that way, because they know that there's a civil justice system out there that holds them accountable. And it's not just safety of products. It's also fair disclosure. It's also, issues in the workplace. It's things like that. People do it not out of altruism. They do it because they know that there's a civil justice system that holds them accountable. So it has its place. Now, yes, there are cases out there that are a little cuckoo. And, like I say to people, frivolous cases by definition are frivolous and get thrown out of court. And lawyers that bring frivolous cases don't stay in business very long. So I don't put much creed in that. So all of that, Daniel, is just my way of getting to this forced arbitration issue, which is the forced arbitration issue in the last 12 years now, since 2010, when the original decision came out from the United States Supreme Court in Concepcion, and its progeny since then, has given license to corporate America to steal small amounts of money from consumers and customers because they can't be held accountable. I mean, who is going to sue and go to arbitration over a $50 dispute, right? So we need to figure out ways to erode forced mandatory arbitration. I know that in Congress, there's been a lot of discussion about eliminating arbitration in the employment setting. And Congress can do this, but Congress can do this. Congress seemingly can't do anything, can't get anything done. So it's unfortunate, because they should turn this back. They should come up with exceptions, not narrow exceptions, but real exceptions to force mandatory arbitration. I mean, I remember reading one case, and don't ask me the site, but I remember reading one case where the court said, look, we're going to uphold the arbitration agreement. But then they went on and said, it's a shame because in modern society, you can't live without a credit card. You can't live without a cell phone. You can't live without a bank account, and they went right down the list. And every single one of those require you to sign mandatory forced arbitration agreements. And so you have no choice.
That's a very interesting point, which is ultimately what signals are being sent to corporations. Let me go a little off script for just a moment here, Brian. I'm going to share something with you, or have a conversation with you, that I really haven't had with anyone else, which is, you've been practicing a lot longer than me. I've been doing this for a decade. So you're a good person to speak with. Corporations are an interesting thing to me. As I began to practice, and I used to think, maybe there would be more of a moral approach, or an approach that really brings justice to the forefront, I began to realize, at least as a consumer attorney, a lot of the ways you get corporations to say uncle is by just letting them know it's going to pinch their bank account. And that seems to be an effective tool of getting them to come to the table. What's interesting about that to me is, at the end of the day, the corporation is run by human beings. But it seems like once a corporation is formed, I'm not talking about some mom and pop shop, I'm talking about a large scale. Once a corporation is formed, the arbitrary concept of a business entity kind of begins to take on its own force and its own momentum, whether by the needs for profit in order to grow the business, whether the needs for profits in order to make shareholders happy. It seems like there's an incentivization for profits above all else. And look, I'm not some communist. I'm a capitalist. Yay, profits. I'm not taking that away. But does it come to a point where that starts to degrade our society? And what's your take on that?
Well, I think corporations are reptilian. I think that they what they know instinctively in their genes is to make money. And if you are the government and you give them the right to push people into forced arbitration, for example, they absolutely will do that because it guarantees that they can make more money. So, I don't think that every single corporation in America sits around and goes, how can we hurt consumers? How can we fuck people? Things like that. I think they realistically think to themselves, how can we make more money? And, oh, wait, forced arbitration, we won't have to worry about legal bills anymore. We won't have to worry about those issues. We can do what we want to do. So I think that that's it. And I think that what the consumer practice of law, let's get out of PI and just talk about consumer and holding, companies accountable, did up until 2010 was it did hold them accountable. It did say, you can't do this. You can't just, rip people off, and you can't shave a nickel here and figure out a way to get a quarter there, because that money adds up. And unfortunately, what I've seen in the last 12, almost 13 years now is it's rolled back, and it now they seem to have a license to do what they want to do.
Yeah. Well, we'll have to see. Is there anything you foresee coming up before we change over to the next topic? Anything you foresee in this arena coming up, changing? Any whispers or thoughts you might have heard in terms of where the legislature's mind is at, whether in the state of California or federally?
Yeah, there's several things. I mean, one is, I mentioned earlier that there was a bill pending in Congress to roll back mandatory forced arbitration in the employment setting and in employment related areas. And the last I checked, it hasn't gotten out yet. And it's a shame. I mean, that one seems to be one that should pass and one that should get to Biden at least before this Congress. And we're recording this in the middle of October 2022. That
not a lot of time left.
Yeah, there's not a lot of time, and we don't know what's going to happen. So, it doesn't look promising. So, it's too bad. Other than that, I think that there's challenges being brought to some of the legislation passed in California that mandate a choice about whether or not you sign an arbitration agreement in employment, and where they can and can't force arbitration. And if those go up to the United States Supreme Court, and the United States Supreme Court does what, especially with a 6-3 majority, does what it probably will do is shoot those down, then state legislatures are going to be impossible to circumvent forced arbitration. The whole thing about, I'll go a little off script. The whole thing about forced arbitration is crazy, is that this is a law from the 20s. It's like 100 years old, about the Federal Arbitration Act. And to bootstrap that into modern day life is just crazy. It's not constitutional. It's just a federal law anyway. Very frustrating circumstance. I think that if this isn't curbed, then I think you're just going to see a continued proliferation of forced mandatory arbitration.
Yeah, absolutely. I'm glad I brought that up to you, as your insights were definitely moving there. Let's move on to the final topic here. And I know you've been very generous with your time today. I won't take much more of it. Let's talk about the plaintiffs bar. I always like to ask plaintiff attorneys this question. I ask defense attorneys this question. I always want to know the perspective of the plaintiffs bar, which both you and I are a part of. Why don't we go biggest of big pictures, and I'll kind of make the question vague and allow you. What is your takeaway, or what is your current consensus on the plaintiffs bar as it sits in 2022 in California?
Well, that's a very big question. So let me put it this way. I mean, I have been doing this over 30 years, and technically I started working in plaintiff law offices in 1981 when I was just in college. So I've been in this community for a long time. And Daniel, I do have a lot to say about this. First of all, the recent survey that came out talked about how much money all lawyers in California make, right? I don't know if you saw that. I don't know if that was widely publicized, but about 70% of all lawyers in California make $200,000 or less a year. And they didn't go any further than that, because I think if they did, the percentage to make $100,000 or less a year would be high. I mean, I wouldn't be half of that. It would be much larger. And then something like 92%, and I'm guessing on these numbers, but it's over 90%, make $400,000 or less a year. So let's first take the fact that most lawyers, the vast majority of lawyers, and it's a very small percentage, make more than $1 million a year. It's like less than 2%. And I can guarantee you those less than 2%, by the way, are white males. So, editorializing here, there's real disparity. And the reason I'm bringing this up is that this is not a money grubbing profession. I mean, people are making a fair living, a good living, in some cases, a very good living. But, it's like I talk about my friends who aren't lawyers, who have businesses, who, are making millions and millions and millions of dollars, sell their business for $100 million, are very successful. We don't have that. So most lawyers go to work each day. They want to represent their clients. They want to do a good job. They want to put a roof over their family's head. They want to feed their family. That's what most people are. Now, the reason I bring that up is because one of the things I've seen is a number of lawyers in our community flaunting their wealth, and I don't like that. And I mean, obviously, there's the Girardi example. I don't want to spend any time talking about that today, but there's lawyers out there, on Instagram, and they're putting out themselves on social media, and they're talking about, where they're going or their trips or what they're doing. And look, I lead a good life. So let me be perfectly clear. I'm not trying to be a hypocrite. I just think we have to be careful about flaunting it in the public, because most of our brothers and sisters in the law are just making a good living. They're not, they're not doing crazy things, buying Italian sports cars, for example, and they're surviving. So that kind of bothers me. I just want to put that out there. The next thing I would say, though, is the quality of lawyers and the quality of work that the plaintiffs' lawyers are doing is in many respects much better than it was 20 or 30 years ago. There are skilled lawyers out there, and you touched upon this, Daniel, in the beginning of the podcast, which is the specialization. And there are lawyers out there who are outstanding employment lawyers. There are lawyers out there that are standing auto defect lawyers, that know this stuff backwards and forwards, that can run circle around the defense. So I see a lot of that. I see a lot of highly, highly skilled lawyers representing people and doing great work out there every single day. I also see a need to get more trials and get more younger lawyers trying cases. And that concerns me. And that kind of brings me to my sort of pet issue, which is we have to make it easier and more affordable to litigate smaller or easier cases. Not necessarily the same thing, but no one should have to spend $100,000 to litigate a $250,000 dispute of any kind, right? And that has to be reined in. But also at the same time, younger lawyers, and at this point in my career, almost everyone's a younger lawyer. Younger lawyers have to learn to do more trials, or have to get out there and do more trials, and there has to be a way to be able to do that. So I mean, those are several issues that I just wanted to start out by pointing out in this discussion.
I think you brought up, an interesting thing, especially in terms of the flaunting of money. I mean, that conversation can be had all the way from lawyers who post their results, which I do. I believe you do as well.
Yeah.
And that's one thing. I always look at that as more of advertising than flaunting. But you're right. There is also the other end of the spectrum, which is the nice cars and the dream vacations and the look at me type of stuff. I do see that. And it's interesting that you bring that up because if I try to reconcile that with what you said before, which is also very interesting, which is the majority of lawyers are not billionaires. I mean, I don't doubt there's any billionaire lawyers, but the majority of lawyers are probably making under $100,000 a year in the state of California. But the boardroom of Corporation XYZ would certainly not want you to think that. They'd certainly want you to think it's a bunch of sharky lawyers. And don't get me wrong, there are sharky lawyers. There are lawyers who file frivolous lawsuits. They exist. Just like there is businessmen and corporations who are sharky and do frivolous things. And between the two of those, who's regulated more? The lawyers. So I always find it a little amusing when we're made out to be like these, legal Satanists that are coming to ruin corporate America. It's a little silly to me. So I appreciate that you pointed that out. Let me bring the conversation. We're going to wrap this up in just a minute, but let me ask you this. You've had a wonderful career. A plaintiff attorney who has a career, a quarter of what you have is a success. I wanted to ask you, being where you are now and looking back and accomplishing as much as you have, what do you wish you knew when you were younger and starting out the practice?
That's an interesting question. I wish that I had tried more cases as a younger lawyer that were smaller cases, because I don't want this to sound self-aggrandizing. I got into larger cases early. I was handling these Northridge earthquake cases when I was a few years out of law school and trying them, and they were big cases. And as we all know, big cases are a lot harder to try, big paper-driven cases, So I wish I had tried a lot of smaller cases, smaller PI cases or whatever, real estate cases, who cares, early on in my career. So I could have gotten a lot of trial experience, in my first 10 years. So I think that's one thing. I think another would be, I don't know. That's a very difficult question, Daniel, to answer. Probably started my own firm a little sooner. Although I was a partner in a firm and a named partner in a firm before that, I think one lesson I would tell people is don't be afraid.
Yeah.
And maybe as a younger lawyer, I was more afraid of things, more afraid of failure. There was a point in my career where I would look at cases and I go, I want like a 90% chance I'm going to win this case, or I don't want to take a try. I don't want to lose, because I went on a long streak where I hadn't lost a case and I was afraid of losing. It wasn't that I was good. It was just, I was only trying to cases I could win. So I think that's a lesson for people to learn is don't be afraid. Don't be afraid of failure. Don't be afraid of doing something. Don't be afraid of getting out in front of something that makes you uncomfortable. In fact, do things that make you uncomfortable.
Absolutely. Okay. Well, Brian, I appreciate you saying that. You're an easy guy to talk to, my friend. I very much so enjoy
I just
this.
talk too much.
No, no, you're clearly intelligent. You're clearly educated. There's no topic I can bring up that you won't add some type of very interesting aspect to it. I could talk to you for hours. I know you got to go. You're like, damn, let's wrap this up. We don't have 3 hours, but I appreciate you coming on. Would love to have you on again at some point in the
Yeah,
future.
my pleasure. I'd love to do it. It was great, and it was a lot of fun. And like I said, don't be afraid. And drive fast and take chances.
I appreciate it. Brian, I'll stop the recording. Ladies and gentlemen, thank you so much.